Good morning, good afternoon, good evening, wherever you are in the world. My name is Hugh Morris. I'm a senior research partner at Zien, and it's my absolute pleasure to chair this engaging webinar today. Now, I can only do that thanks to the generosity of our sponsors. And our sponsors allow us to range widely and freely across technology, economics, finance, and related subjects, and to put on the interesting program of webinars that Zien is proud to launch. Now, looking at the agenda, we have got Rob Davey and Elliot Davies, who are going to talk about unitary patents, the new way to protect intellectual property in 2023. And that's going to be a subject, I think, of great interest to anyone who is creating innovation and looking at the market. Now, some housekeeping notes. The slides are available to download in the chat and on the website. We'll be holding a roughly 15 to 20 minute Q&A after the completion of the remarks from Rob and Elliot. And we very much welcome you to send in your questions through the chat facility, and I will then be delighted to relay them to the speaker. Now, my job is to get out of the way. So without further ado, I will hand you into the capable hands of Rob and Elliot. Gentlemen, over to you.
Great, thank you, Hugh, and thank you to Hugh and the team for the invitation to speak today. It's a great pleasure to talk to you about the changes that are happening in the European intellectual property landscape in the next few months. We are from AIPEX, which is a pan-European law firm. I'll speak a little bit more about that in a moment, but if we can go to the next slide, just a little bit about Elliot and myself. So I am the CEO of AIPEX. Based today at my home in London, but our head office is in Rotterdam in the Netherlands, which is where I spend some of my time. And we also have Elliot Davies, who is one of our patent attorneys, based in Cardiff, also in the UK. And Elliot will be doing most of the legwork today to explain to you what the Unitary patent is. But before he does that, if we can go to the next slide, just a little bit more about who AIPEX are. So we are a pan-European law firm. We are in 12 countries, have about 25 offices around Europe in those 12 countries, as I say. And we can offer a truly one-stop shop for intellectual property management. So the traditional way of managing IP in Europe is often to go to the different national law firms and work with maybe up to 28 different law firms around Europe. But as well as the Unitary patent, as you're hearing, streamlining that process, AIPEX is able to streamline that process by having one central office, as I said, in Rotterdam, where we have our team who manage our client relationships and who are able to provide that seamless service and make things much more efficient for customers. So that is who AIPEX is. We work across all intellectual property, patents, but also trademarks and industrial designs and copyright and so on. So that's enough about us. You came here to learn about the Unitary patent, and for that, if we go to the next slide, we'll pass over to Elliot.
Many thanks, Rob. Okay, so today we'll be giving a presentation on probably the biggest and most dramatic change to the European patent landscape for over a generation. And of course, I'm speaking to you of the Unitary patent and the introduction of the new Unified Patent Court. But before we discuss these changes, I thought it would be useful just to cover some of the current mechanisms for obtaining patent protection so that we can compare and contrast. Okay, next slide, please. Okay, so here we can see a map of Europe with various countries indicated with their national flag. Now, patents are territorial. So a UK patent, for example, will enable the proprietor to control the exploitation of the invention in the UK. If you want protection across a number of different countries, then it's necessary to obtain national patents in those countries. And the most basic means of obtaining the national patents is by filing patent applications directly in those countries. Now, each application is subject to a separate examination. It's quite an intensive process, requires careful coordination, and more importantly, it can be quite expensive filing applications directly in each country of interest. But the end result is that once the national patents have been obtained, they can then be enforced, and this is done at the national level via the national courts. So to take action in Germany, for example, you would enforce your German patent. Next slide, please. Now, the 1970s saw the introduction of the European Patent Convention, and with it, an alternative mechanism for securing patent in Europe. The convention established the European Patent Office and the concept of what we know today as a European patent application. Now, a European application enables applicants to file a single application covering a number of European states in one go. And it's important to note here that the member states of the convention are not the same as the member states of the EU. In fact, the EU states are a subset of the European Convention states, and these are shown in red on this map. Now, a European application is examined centrally at the European Office, and once any objections have been overcome, the application will proceed to grant. So as you can see, the European application enables an applicant to obtain a patent covering a number of states with only a single application procedure in one language and with a single set of official fee payments. So it's much more cost effective in obtaining a granted protection across a lot of the European countries. Next slide, please. However, once a European application grants, it's then necessary to select those states in which the European patent is to be made effective, and this is known as the validation stage. Now, the validation stage is different depending on the particular state, but it can also involve submitting translations of the granted patent in the local language. So again, there can be a significant charge after a European application is granted in order to make the patent effective. But nonetheless, once the validation stage is complete, the single European patent will then effectively become a bundle of national patents, each of which is a standalone patent, just as if it had been obtained via the national filing procedure. So as you can see, a European application offers a benefit in obtaining a granted patent, but then post-grant, the procedure for enforcement and validity is largely the same as if national patents were obtained via the national route. Next slide, please. Okay, so with this backdrop, let's now consider the new unitary patent. Now, essentially, a unitary patent is a new patent which enables proprietors to cover a number of states, 17 in fact at the moment, in one go. Now, a unitary patent is only obtainable via an existing European patent application. So if you have a European application pending at the time the unitary patent regime enters into force, and this is currently expected to be the 1st of June this year, then you have the option of requesting a unitary patent. Now, another point to note is that the unitary patent only covers EU states, and at the moment this is 17 of the possible 24 EU states, and these are shown in dark blue on the map. It's currently only 17 because only 17 states have ratified the agreement, and it's only possible to have 24 because Spain, Poland, and Croatia are not taking part. So the unitary patent is available only as part of the validation process. But instead of making a European patent effective in 17 states, by selecting a unitary patent, you can cover this new pseudo-region of 17 states in one go. Now, for all the other states, which are not party to this new agreement, such as the UK, it would be necessary to follow the classical validation procedure to obtain the national patent. And just to be clear, you're not required to select a unitary patent. The classical way of obtaining national patents is still an option. If you only want protection in Germany and France, for example, then you simply make a European patent effective in those states and not bother with a unitary patent. So as you can see, going forward, a European patent may give rise to a bundle of national patents and a unitary patent covering 17 states. Next slide, please. So what do you need to do to get a unitary patent? Well, once your European patent application has granted, the normal validation deadline for making a European patent effective is 3 months from the grant date. So if you wanted a national patent in Germany, for example, you'd have 3 months in which to make it effective in Germany. However, for a unitary patent, the validation deadline is shortened to only 1 month. So decisions will need to be made quickly as to whether or not a unitary patent may be suitable for you. Now, there's no official fee associated with making a request for unitary effect. We are required to submit a form to the European Patent Office, and this will need to be accompanied by a translation of the European patent into any other EU language. Now, over time, as more states ratify this new agreement, the territorial coverage of a unitary patent will grow. But going forward, it's important to note that there will be different generations of unitary patent. But the territorial coverage of a unitary patent, which has already been obtained, will not be extended as new states join. So the states that will be covered by a unitary patent will be fixed at the time the European application grants. Next slide, please. So just to give a little real-life example, if an applicant of a European patent application would like to extend their protection to, let's say, the UK, Germany, France, Italy, and Spain, then once the application grants, the proprietor would be required to validate the European patent in each state separately within 3 months of the grant of the European application. And as I mentioned before, this can involve submitting a translation of the patent into the local language, and it will also require the ongoing payment of separate renewal fees to keep each national patent in force. But the end result is that the European patent would give rise to 5 separate national patents. Next slide, please. However, once the unitary patent system enters into force, proprietors will have a further option for covering the 5 states. Now, proprietors will still need to use the classical validation process to cover the UK and Spain, as these states are not part of the unitary patent system, but proprietors can choose to cover Germany, France, and Italy, and indeed the 14 other member states, with a single unitary patent rather than the separate national validations in Germany, France, and Italy. Now, to give you a bit more insight into the costs associated with this unitary patent, I'll pass you back to my colleague Rob.
Great, thank you very much, Elliot. So let's have a look at the costs. And when you're thinking about patents, there are various costs that need to be considered, including the examination costs and the validation and maintenance costs, but then also the cost of litigation. But if we look at the first few costs there, both examination, so Elliot has mentioned that there is a process to examine and decide if that patent is valid or not, that will happen at the EPO. And then there are the validation either in all the different countries or via the unitary patent that would need to be paid. And then maintenance costs. There are annuities, payments that need to be made at different stages throughout a patent's life that need to be paid, that will be different depending on which strategy you go for, whether you go for national or unitary patent. So we go to the next slide. There's a screenshot here, or there should be, yep, screenshot of a tool which is actually on our website. It's free to use, where you can plug in the countries that you might be interested in or that your current patents cover when you're filing in Europe, and you can compare the costs for those examination and for the maintenance and renewal costs and validation costs. You can compare all of that using this tool, which looks at the average fees for these countries. So if we look at this first example here, this is an example where there's filing in 10 different countries. I won't read them all out, you can see them there, but there are a mixture of countries, some of which are within the unitary patent, as Elliot has just mentioned, and some that are not, such as the UK and Spain. And if you were filing, or if you are filing today in these 10 countries, then with the unitary patent, when that is introduced later this year, There would be a saving over the lifetime of the patent. So the current system, and if you stuck to that current system, would cost you 95,000 euros overall. It would be 70,000 euros if you went with the unitary patent. It's worth saying here at this point, cost is not the only factor that you should be considering when you are deciding if you're going to go with the unitary patent. Elliot will talk in just a moment about the litigation side of this, the Unified Patent Court, which has some advantages and some drawbacks. So that is something to think about, and also the strength of the patent may be something that you would want to think about, whether you want to make that a wider patent than otherwise. Because don't forget, as well as these 10 countries, you are also getting another circa 10 countries or so that are in the unified patent as well. So cheaper, but other considerations to think about. But it's useful to know where that cost would be. If we go to another example on the next slide, then here we can see if you stuck to your current strategy and you were just filing in Germany, France, and the United Kingdom. Then essentially that is just 2 unitary patent countries, Germany and France, and UK is outside. So if you stuck with the current way of filing those, then that would cost you 33k. But if you went with the unified patent, it would actually be more expensive at 48k. Now, don't forget, again, you're getting another 15 countries at least, as well as France, Germany, and the United Kingdom, and maybe more in the future. So maybe it's worth that extra expense. But it is worth noting that it is more expensive to use the unitary patent if you're going down this route. If we go to the next slide, I believe there are some examples here of where they're just a summary of what we've just talked about, of the fact that it could be cheaper, could be more expensive depending on your strategy. But litigation costs we haven't really covered. And that Elliot will talk about in a moment. Could be more expensive than before 1 or 2 national courts, but could be cheaper. Again, if you had to take a patent to court in many countries, then that could be much more expensive than the unified patent as well. So that is worth considering. But for more on that, I'll pass back over to Elliot on the litigation situation in front of the Unified Patent Court.
Thank you, Rob. Yeah, so as Rob mentioned, as well as the unitary patent, we get this bonus of a new Unified Patent Court. And this new Unified Patent Court is has exclusive jurisdiction to hear matters relating to unitary patents. Now, the Unified Patent Court has its principal division, the main seat, if you like, in Paris and Munich. And each member state is expected to establish its own local division. Now, the judges for these courts are currently being trained. There was a recruitment program over the summer and followed by a training program. And I believe these judges have now been appointed, but it's important to note that there's no case law for this new court. The judges haven't yet actually heard any cases, and so there's no precedent. So it's very difficult to know how certain cases are going to be. It's difficult to predict the outcome. We don't know the outcome of an infringement or a validity case, for example, because it just haven't taken place yet. But with a unitary patent, what we do know is that a decision from a single court, so for example, a decision from the court in Portugal that a unitary patent has been infringed, will also be binding on all other member states. So if you have a competitor maybe in in France, Germany, and say Sweden, and you launch an action in Portugal for infringement, then you won't need to conduct separate legal proceedings in those other states for that enforcement to take effect, which is quite good. You get this countrywide, well, inter-country-wide decision, which has an effect in all those states. Next slide, please. It's also to note that in contrast to some of the German courts, where an infringement proceeding will take place separately to a validity hearing, under the new Unified Patent Court, unitary patents will be assessed for infringement and validity at the same time. But equally, as I mentioned, whereas a favorable decision that a unitary patent has been infringed in one member state can be used in all other member states, on the flip side, if a decision is that the unitary patent is invalid in one member state, then you could lose protection across all member states. And this is what we refer to as sometimes a central attack. So a decision from the French court that the unitary patent is invalid will also be binding in Italy, for example. So this is where we need to weigh up the options about whether a unitary patent is actually an important strategy for you. If it's if it's a business critical patent, then you may not want to expose this portfolio, your patent, to a central attack. And so you may wish to pursue national patents instead. Next slide, please. Now, the Unified Patent Court has exclusive jurisdiction to hear matters in connection with unitary patents, but, and if you can go to the next slide, please, the Unified Patent Court will also take default jurisdiction over existing European patents which you've already obtained. So if in the past you filed a European patent and you've made it effective in France, Italy, and Germany, for example, then the Unified Patent Court will be the default court to hear all matters relating to infringement and validity. So again, like I said, this is an untested court, so it's questionable whether you would like this court to adopt the jurisdiction. And if you don't want this new court to have jurisdiction over your existing patent portfolio, then you will have an option to what we call opt-out. Next slide, please. Now, the ability to file an opt-out request to effectively opt out of the jurisdiction of the Unified Patent Court is only available for a 7-year transitional period at the moment. There is going to be another decision made at the end of the transitional period about whether to extend that period itself. But for the first 7 years, if you would like to opt out your European patents from the jurisdiction, then you can do so. But you will have to actively do so, because if you don't, the new court will take automatic jurisdiction. If you don't opt out and a competitor, for example, launches an action that your patent is invalid in Germany, and if that action is started at the Unified Patent Court, then it has to commence. Now, this could be problematic because a decision that your German national patent is invalid will also again be effective in all the other member states in which your European patent has been made effective. So again, keeping your existing European patents under the jurisdiction of this new court may create some vulnerabilities to this central attack. After the 7-year period, after the transitional period, the Unified Patent Court will be the only court which is capable of hearing matters relating to European patents. So this option to opt out is only available at this time for the next 7 years. And if you opt out now, then that opt out is deemed effective for the life of the patent. Next slide, please. So just to give you a little example, if you have a current European patent and you've made this patent effective in 5 countries, UK, Germany, France, Italy, and Spain, then under the normal way of doing things, if you wanted to take action against an infringer in France, you would need to enforce your French patent at the French national courts. Now, each national court will have a different set of judges, a different set of precedent, and so decisions from one court to the other may vary slightly. Next slide, please. Under the new regime, if you don't opt out your European patents from the jurisdiction of this new court, then you have the option of taking action against an infringer, for example, in Italy, Germany, and France by this new court, the Unified Patent Court. However, if you wish to take action in Spain and UK, then you would need to continue to use the national courts and enforce your national patents. Next slide, please. So by lodging an opt-out request to effectively remove your European patents from the jurisdiction of the new court, you can shield your portfolio from this central attack. Next slide, please. If you decide to withdraw, or if you decide to opt out your European patents from the jurisdiction of this new court to shield them, then you do have the option of withdrawing that opt-out to effectively opt back in to the jurisdiction of this new court. And that may be a very important strategy. You may wish to take action across a number of states in one go by using the Unified Patent Court. If you do opt back in, then you can't then opt back out. So that's an important thing to note. You can only opt out of the jurisdiction of the court once. Next slide, please. Sorry, next slide, please. And if you do opt out, then the situation is exactly the same as it is now. You will have to enforce your national patents at the local courts, and equally a competitor wishing to challenge a national patent would have to do so separately at each national court. Next slide, please. So just to recap, there are a few options to consider here. As I mentioned, you have the option of selecting a unitary patent to cover a number of states in one go. That's so you can obtain protection across a number of states. Equally though, a separate decision has to be made as to whether you wish to use the jurisdiction of the Unified Patent Court to enforce your rights and or challenge third-party rights. So these decisions need to be made separately, and just to recap, with the Unified Patent Court, you have to actively decide to opt out. If you don't opt out, then this new court will take automatic jurisdiction. Okay, any questions, please?
Gentlemen, thank you very much indeed. What a fascinating review around this. A seriously interesting subject. So yeah, we have some questions, definitely. So Luca Frost has asked, are unitary patent requests available to pending EU applications made under the PCT?
Yes. So if you have a European patent application which is derived from an international application, then you can certainly file a request for unitary effect. Okay,
fabulous. Thank you. Hugh Purser asks, could you please clarify what you mean by different generations of unitary patent?
Yes, first of all, I'd like to apologize. It was a canter through all the various legal issues, so I did gloss over that point a little bit. So if you were to file a request for unitary effect as of today, then that unitary patent would cover 17 states. If maybe next year another state joins the new regime, then if you were to file a unitary patent at that time, it would cover 18 states. But importantly, the unitary patent that you obtain today will not be extended to cover that additional state. So, and the important, the cutoff date is effectively the date on which your European application grants. So the number of the states which have ratified the agreement at that time will be the states which are covered by the unitary patent.
How do you see this changing the landscape of the whole patent management process, and particularly for firms like yours?
It's caused a lot of headaches because there's no one-size-fits-all answer. You know, there's no best option here. You really have to take each case, each applicant independently. I've heard that some companies, some car manufacturers are deciding to go all in and keep all their European patents under the jurisdiction of this new court. Other companies are decided, no, we're opting everything out because we just don't know how this court is going to develop. We don't know how the judges are going to react to an infringement or an invalidity action. We have no idea. We don't know if they're going to be biased by or take some inspiration from their local cases that they've handled nationally. So it's a real mixed bag at the moment. But I think it's important to say that if you are concerned, if you do have some very business critical patents, then I think it's wise to opt at least those out of the jurisdiction of this new court. You can always opt back in later.
Okay, because I was going to go on to ask, what's your recommendation? Should we be opting in or opting out for existing patents?
Yeah, and there's no direct answer to that. I think, like I said, I think the important thing is to make sure you opt out your important patents, and you have to opt out before an action is commenced at this new court. If, for example, on the 1st of June, when this unified patent court comes into existence effectively, if a third party was to file an action to invalidate your patent on that date and you hadn't opted out, then you have to continue the proceedings through that court, and therefore you're vulnerable to a central attack. So if you are wanting to shield your patents, you need to opt out as soon as possible. And this earliest possibility to do that is from the 1st of March, which is the start of the sunrise period.
Yes, because I was going to say, what are the launch dates? And it sounds like there are a number of them for the new system.
Yeah, I mean, the original launch date was supposed to be the 1st of April. That would have started the sunrise period on the 1st of January. But that got pushed back for various reasons. And so the formal start of the sunrise period is now the 1st of March. And the new agreement, the new Unified Patent Court agreement, will start formally on the 1st of June.
And in terms of the different countries, do you think there's going to be, based on local factors, different take-ups around Europe? And what's your assessment of people's readiness to handle this?
That's a good question.
That's a good question.
I mean, it's very difficult to predict. I think there are some countries that are seeing this as a great thing, and that you might see people in those countries being more likely to use it. Germany being one. One of the courts is going to be based in Germany, and I'm certainly hearing more Germans saying that they want to go for this than not. But it's still split, even in a country like that. So I think it's more going to depend on the individual company's risk profile, how strong their patent portfolio is, what their filing strategy is. There are some companies who only really ever file in 2 countries because that's their major markets, and of course they may decide to carry on as they are. So I think it's more the individual companies and maybe industries rather than countries, but there are some national differences. Elliot, I don't know if you've seen anything different than I've seen there.
No, I think you've covered everything there. I think there is an appetite for it in Germany. Yeah, I think it's a case of maybe we just have to wait and see how things develop.
And certainly your clients are among the more switched on, we know that. But do you think companies are ready for this? Do you think they know about this?
Hopefully. We've given quite a few webinars. We've made a lot of noises, and this hasn't been something that's been dropped on us. This has been incoming for the last 6, 7, 8, 9 years, and we've been crying wolf for a while now. And I think the risk was that our latest messages have just fallen on a little bit of a deaf ear, because people seem to think, oh yeah, okay, you've been saying this for the last 6 years. Is it actually happening now? Well, yes, it is happening now. So.
Yeah, I was going to say something similar. As I've been at IP conferences around the world, particularly in the US or in Asia, I think there's a certain amount of people in those regions who've been hearing European patent attorneys come over and talk to them about this for 10 years now, and they're kind of, is it really going to happen? But I think the point is now it really is going to happen. Those dates that Elliot mentioned are looking extremely firm now. So yeah, I think there is some work to be done by the European IP profession to make it very clear to everyone around the world that this is coming now. It is real, and it's time to make those decisions on opt-in or opt-out. And that doesn't mean that people need to sit down and listen to a presentation like this one to really understand it, because as we've seen today, it's not an easy procedure. It's not. It's come out of various years of negotiations at the European level to decide what these rules will be. So they are fairly complex. So it does need people to sit down and understand the decision that they need to make.
And I think we've time for one more question, and Hugh Purser has kindly popped up with another excellent question. What kind of appeals process exists? 1, for decisions made at country-specific UP courts, or 2, the top European level courts in Munich/Paris?
Sorry, I don't fully understand the question, but yes, there is an appeals process available, and the appeal seat will be in Luxembourg. I'm not too sure what the question was asking there. Could you repeat it maybe?
So it was saying, what kind of appeals process exists? One, for decisions made at country-specific UP courts, or two, the top European level courts in Munich and Paris.
Okay, yeah. So the appeals will be to the dedicated court. Appeals from the local division, even regional divisions, will need to be done by the appeals based in Luxembourg.
Very good.
I believe the appeal deadline is quite short as well.
Is it?
It's a month. I think it's 1 month to appeal.
Wow. Yeah, that isn't long, is it? Gentlemen, Rob, Elliot, thank you so much. I thought that was riveting. It's something we all need to know about, and it's a big, big change coming through. So greatly appreciate you sharing your thoughts with us today. Thank you very much indeed to our sponsors. Once again, we could not do this without you, so thank you so much. Thank you very much to the audience, wherever you may be in the world, for attending. And thank you so much, Elliot and Rob, for giving us an outstanding session today on a subject that we all will need to grapple with. Thank you very much indeed. I wish you all an outstanding remaining of the day, wherever you are in the world. Thank you and goodbye.
Thank you.